Criminal justice in a nutshell. My name is John Fisher, Dr. John Fisher, and today in Criminal Justice in a Nutshell we're going to talk about modification, revocation of probation and parole. Now, I am filming here today at the Moss Lake RV Park in Big Spring, Texas. Well, actually it's about 8 miles south of Coahoma, in the Coahoma area, but it's the Big Spring address. Here there are 16 RV spots that hold my rig, and I have a 36-foot rig. 8 or 9 of those spots have full hookups, electric, water, and sewer. The remainder just have water and electric. But anyway, let's get on the ball here. Today we're going to be talking about modification and revocation. And before we can get there, we need to talk about early termination. Early termination was the first thing that was covered in the chapter by Allred. And in some jurisdictions, the defendant can apply for early revocation or early termination, being dismissed from probation early. Some of the reasons why you are dismissed early is because you've fulfilled all of your needs, you've fulfilled all of your requirements. You've gone to drug school, you've gone to alcohol school or anger management, you've done all of your community service, you've paid all of your fines, and you've done everything that was part of your conditions for being on probation or parole, and you've completed all that, and you accept for the time. So you can apply to the court to say, hey, I've accomplished all this, I've done all this, let me terminate. Occasionally, and this is very rarely, an officer will apply for the offender or in the offender's place and saying, hey, you've done all of this, you can go ahead and be terminated from probation. It's not done very often, and in some of the jurisdictions that I've worked as a probation officer, the probation officers weren't even supposed to bring it up. Maybe that's because the probationer has to pay fees every month, and every month that they're on probation. In fact, they have to have their fees paid off prior to 3 months of the termination. So you have to actually work your way to where you're paying your probation fees 3 months in advance. You can also receive modifications because of good behavior. You can have your probation changed. You can have your curfew extended, where most of my defendants, when I was a probation officer, my defendants were required to be in their homes by 9 o'clock. If they're good behavior, they're following all the rules, they're getting everything done, maybe you can have that curfew extended to midnight or some other time. Or you can have a decrease in office visits. As a intensive supervision probation officer, part of the ISP, all of my defendants were substance abusers. They had just been released from one form of a treatment facility or another, and when they first get out of SafeP or CRTC or one of those residential treatment facilities, they have to see me once a week. They come into my office once a week, and I visit them twice a month. So there's 6 office visits, or there's 6 visits between me and the offender every single month. As they progress and as they're becoming successful, we can decrease that. There are level 1 offenders that never have to see their probation officer. They just send in a form every month with their money order for their payments because they don't have to see the probation officer. Okay, so there's lots of different things that you can do for good behavior and because of good behavior. The federal side, on the federal side of probation and parole, there's an 82% success rate. Okay, 82 out of 100 people successfully complete probation. Is this done because of the different tools that we have? We find out what their risks are, we find out what their needs are, and then as a probation or parole officer, we're going to adjust their supervision to meet those needs and to address those risks. When there are revocations, In the 18% of the times that there are revocations, 11% is because of technical violations. And I guess at this point we need to talk about what can get your probation revoked, or what can get it modified. The first is a technical violation. The second is because you've committed a new crime. Immediately, every jurisdiction I've ever worked, the federal government, for the most part, if you commit a new crime while on probation, you're automatically, a motion to revoke is automatically filed with the courts to revoke your probation and send you to prison or jail or whatever the stipulation was for your probation to fail. So we're looking at an 18% failure rate, or an 18% closure rate early. 11% is because of technical violations. They did not complete their probation requirements. They didn't do their community service. They didn't pay their fees and fines, and we'll talk about fees and fines here in a minute. But they were supposed to go to drug rehab, and they didn't go to drug rehab. They were supposed to attend AA twice a week, and they didn't do it. They were supposed to have a curfew, and they never met the curfew. They were supposed to maintain employment. They didn't maintain employment. These are all technical violations. And once a probation officer, and there's no polite way to say this, but once a probation officer has decided that you're a lost cause and he or she is no longer going to work with you, they're going to revoke you. Okay, they're going to keep all of these technical violations in a file, and when they're done playing games, when they don't want to mess with you anymore, they're just going to file a motion to revoke and have your probation revoked. 5% of all failures are caused because of a new crime, because they got busted doing whatever they were doing before. The other 2% is because of an administrative closure. The administration decided, the judge decided that you weren't supposed to be on probation. There was all kinds of different reasons for this, but your probation is effectively closed and you're sent to prison. State level, the national average is between 60 and 70% success on probation, 49 to 57% on parole. These success rates are atrocious. My success rate was 87%. 87% of the people that were placed on my caseload successfully left my caseload. And then they went on to successfully complete their probation terms. And we track them. We track successful probation up to 2 years after removal from probation. So after 2 years of being on probation, if you have not committed a new offense, you don't have any problems, they consider that a success. Okay, so when considering modification on whether or not you have to, as a probation officer, you have to determine whether or not those changes are going to be beneficial, whether or not those changes are going to help the offender become successful in rehabilitation and becoming a productive member of society. So we sit here and we look at these things and we talk about rehabilitation and these assessments and these needs, risks, and whether or not, I know a couple weeks ago we had a discussion on recidivism rates and the risk of recidivism. You know, if we determine as a probation officer that this guy is not going to be successful and he's not going to become a productive member of society, we're going to wash our hands of him and send him off to prison. You know, we need to make sure that as probation officers, we don't succumb to self-fulfilling prophecy. In fact, I challenge you this: if you want to become a probation or parole officer within this country, you have to have a mindset that you want to bring about positive social change to the world. I know that's a liberal progressive term, but it's true. If you do not think that, or you do not have this desire to bring about and to make a better world, you don't need to be a probation officer, because what we do in modification and revocation is just that. We're bringing about social change. As probation officers, we can change the world one defendant at a time. Granted, we see a whole lot of failure and we see a whole lot of disappointment, but we can bring about positive social change, one individual at a time. Okay, and we need to keep that in mind as we're going about doing our business. Okay, so we need to keep that in mind as we're going about doing probation. Okay, so revocations have and parole have from probation and parole at a rate of about 35%. So again, there are two types of violators within probation and parole. First are the law violators. They've committed a new crime. Typically this results in an automatic MTR. It results on the probation side, an automatic blue warrant on the parole side, to where probation and parole are recommended for revocation. It's not up to the probation officer or the parole officer. So I'm going to let you in on a little secret here, that probation officers, and I know I have, and my bosses have, people I've worked for, that all these probation officers tell you the same thing. You screw up, I'm going to revoke you and send your ass to prison. You can't do that. That's the secret. We as probation officers and parole officers are pretty much nothing more than glorified babysitters for the judge and the court. We report to the court the actions of the defendants and the offenders that are on our caseload, and then we make recommendations to the court. Right, I recommend to the court that we revoke and we impose the full prison sentence. I recommend that, yes, he's committed this new crime, he has continued using drugs and alcohol. I recommend that he gets sent to a substance abuse felony punishment facility for a period of 6 months. Okay, so he's going to spend up to a year in jail waiting to go to SafeP. Then he's going to go to SafeP. He's going to be in SafeP between 6 and 9 months, depending upon his success. And then he's going to spend another 3 to 6 months in a halfway house. And then he's going to be released back to you on probation. But is this going to help? We have to make this decision and determination on any modification that we make. Is that going to help in the long run? 60 to 70% of parole revocations are because at the state level are committed because of a new offense. Technical violations is the second type of violator, probation violator, and that is because they violate the conditions of supervision. Okay, when you get placed on probation, when you get placed on parole, you agree to a certain number of things, and everybody has the same 13. You will maintain it. You will not commit any new offenses. So committing a new offense is not only committing a new offense, it's also a technical violation because it's a condition of your probation not to commit another offense. So not to commit another offense, not to go to bars, not to hang around felons, not to use drugs or alcohol, to submit to your analysis. A lot of all probation and parole have a curfew unless their job gets in the way of that curfew. If you're not, you're supposed to be at home by 9 o'clock. If you're not at home, you better be at work. And when you get off work at 12 o'clock or 1 o'clock or whenever you get off work, you have to go straight home. If I catch you at the bar, if I catch you at McDonald's when you're supposed to be at home, it's a violation of your probation. Okay, so this does allow for more discretion on the part of the probation officer. I know my policy, you got busted the first time for marijuana. I didn't revoke you. I sent you to outpatient therapy. I sent you to increased counseling. I made you do increased AA meetings or NA meetings. When I got the drug issue, your third positive for marijuana is when I would file for revocation, because when you're dealing with technical violations, the probation officer, parole officer has a whole lot more discretion on what to do with those. Okay, so but first time you pop positive for methamphetamines or cocaine or heroin, PCP or any of the other hard drugs, or what we call hard drugs, I filed an MTR and recommended you be sent to safety first time out. Second time out, if you pop positive again before the MTR was decided, yeah, I just said prison. So, absconding supervision, this is a big deal. Okay. Keep hanging up. So, absconding supervision is a big deal within our world. Absconding supervision is the same thing as escape. Okay, when you're placed on probation, you're still pretty much sent to prison. You don't have any of the rights. You don't have your rights to privacy. You don't have the right to remain silent. You don't have the right to against self-incrimination. These are all court cases that have been to the Supreme Court. As a probationer, as a defendant on my caseload, I can go into your house and search it for anything I want whenever I want. I don't need an additional warrant. You are technically in prison. Your prison walls are the county. Okay? And you're required to come see me once, twice, 4 times, however many times I determine that you need to see me. After 90 days of not making a visit or not hearing from you, you are considered an absconder, and you will have a motion to revoke filed against you. You become a fugitive. Most jurisdictions take a passive approach to finding fugitives. They really don't care. I took it personally. You escape from me, I will hunt you down. I will find you. I'll make sure there's a warrant for your arrest, and I will, once I find you, I'll call the local authorities and say that there's a warrant out of the state of Texas for you, and have the police go arrest you. But a lot of people don't really worry. They file the motion to revoke, they get the warrant to arrest, and then they don't worry about it. As long as you don't get into trouble, as long as you're not getting arrested, nobody's going to know that you've absconded from probation. And that's really, really sad in my opinion. In-house progressive sanctions are sanctions that I can do as a probation officer, you can do as a probation officer, that are oral or written reprimands. A lot of times they'll require staffings, and I never made a decision. Yes, I had a lot of discretion about what I did as a probation officer, but I didn't make any final decisions until I staffed this with colleagues and my supervisor. Every week or every other week we'd have a team meeting where the supervisor and the team, there were 6 of us on the substance abuse team, and we would sit down, we would talk about our offenders. We would have a list. I had 67, 75 offenders on my caseload, and every week I would pick 5 or 6 to talk about. This guy's doing great, this is what we've done, this is what's working well. And then we'd also talk about guys that, this isn't working. I've done this, we've done this, we've done this. This is what I think I should do next. And as a team, we would talk about what was the next step? What was the next thing that we could do to try to make this individual successful in his probation? And so additional sanctions were also set by policy. And this was to ensure that probation officers were not overstepping their authority. Okay, any major modification to probation had to have approval from the courts, and this made sure and ensured that the probation officer was not overstepping his bounds, his authority, what he can and cannot do. Okay, when the strategies to finding a way to rehabilitate and to help the defender aren't working, and we have tried absolutely everything that we can do, the community supervision officer is going to recommend revocation. Okay, and the revocation rules are governed by the Constitution, by the state, by agency policy. All MTRs are started by the community supervision probation officer filing a motion to revoke. He takes this motion to revoke, and he fills out this court document. It's called a motion to revoke. And he takes this court document to the DA. And the DA will review the document. He will make sure that this document is within accordance of what it's supposed to be. And then he will, if the DA believes or he agrees with the situation, he's going to recommend revocation. He's going to sign off on it. And then after the DA signs on it, it's going to go to, there's going to be an arrest warrant issued. And, you know, a lot of times, you know, you'll also, when I was down in Alpine, after the DA signed it, it went to the judge. The judge signed for a warrant to be issued. And while I was in San Angelo, we would just wait till they came in for their next visit. And there's a whole lot of debate on whether or not you should tell your offender, your defendant, whether or not you're going to file a motion to revoke. I would think that they would already know, so I always told them. You know, I said, hey, Logan, I'm going to file a motion to revoke, so next time you come in, you're probably going to be arrested. Well, if you knew you were going to be arrested, would you come in? Probably not, which would add a charge of absconding and add a charge of escape, which adds a minimum of 5 more years in prison. See? But my defendants, I told them when I was going to file a motion to revoke, and they came in to be arrested. I had a reputation, I had a level of respect with my defendants that they respected, and they were, you know, for the most part, I would say 8 out of 10 of my defendants that I revoked and sent back to prison, or filed a motion to revoke to be sent back to prison, were disappointed in themselves as much as I was. Okay, so after the judge signs for the warrant, there is an arrest is made. They sit in jail until they have the hearing on their motion to revoke. Most jurisdictions do not allow bail while you're waiting a motion to revoke. You have the hearing. The defendant will give their case. They'll plead their case in front of the judge, and then the judge will make a decision, you know, on whether or not to modify or to revoke. 9 times out of 10, the judge is going to do exactly what the probation officer has recommended. Okay, so this is a 2-stage process. Okay, there's a preliminary hearing to determine whether or not there's probable cause. The first hearing is to determine whether or not the probation officer has done his job, he's done his job correctly, and that there was probable cause to ensure or to revoke or to require the arrest. And then there's the final revocation hearing. This is a due process hearing. Your lawyer's allowed in the room. You fight over facts, and it has to be done before supervision can be revoked and the defendant is sent to prison. Okay, mandatory revocation. At the federal level, mandatory revocation includes the commission of any new crime or sexual contact against a child, possession of firearms, possession of controlled substance, or a positive drug test. I know here a couple years ago I used to do urinalysis. I was a subcontractor for the Federal Probation Office, and I would do urinalysis for people on probation, on federal probation here in Big Spring. And it would be funny, I'd see the same people every month, and then one month somebody wouldn't show up. So I go, hey, has anybody heard from so-and-so? And they go, no, he got busted, he's back in jail. His last urinalysis popped positive. And he goes, you know, there's a blue warrant issued, he goes right back to jail, no questions asked. Or a refusal to comply with drug testing. And that was something else that was interesting. I had, I don't know, 65 guys here in the Big Spring area that had to come pee for me. And it was on any given day of the month. They were notified at 3 o'clock in the afternoon. They had to report to the urinalysis center by 5:30. They had until 6:30 to show up. They had until 7 to pee in a cup. And if they refused to pee in the cup by 7 o'clock in the evening, it was considered a refusal to comply with drug testing. A blue warrant was issued, and they were immediately sent to jail. Okay, at the state level, it's about the case and the individual specific cases. If you collect a new charge, the motion to revoke is going to be filed. Whether or not they revoke your probation is going to be a different story. They can have different avenues, different options that will change the way that happens. So some legal issues. A motion to revoke hearing is an administrative hearing because it is an extension of the existing sentence. And that was Hampton versus the state 2001. Gagnon versus Scarpelli in 1973 and Morrissey versus Brewer in 1972 stated that due process rights given to the defendants will also extend to the motion to revoke hearings. The People versus Price in 1960. The offenders do not have the right to a jury or the right to a speedy trial. If we want to leave you sitting in jail for 2 years waiting for an MTR hearing, that's what's going to happen. You have no right to a jury trial or to a speedy trial. Perry versus State. The offenders are not entitled to Fifth Amendment rights to self-incriminations. Okay, now I mentioned that at the top. You, as a defendant, you do not have the right to remain silent. You must speak. The level of proof is a preponderance of the evidence. Okay, when we're dealing with revocation, it's not beyond a reasonable doubt. It's, does the judge believe me? Does the judge believe what I have documented and the documentation that I have showing that the defendant did not do this or they did this or what issues that they have? And that comes out of the United States versus McCormick in 1995. Benton versus State. Okay, the arrest by itself is not enough to revoke probation. There's got to be something else, according to Benton versus State. And there normally is. If you've been arrested for something, there's always other technical violations that'll get put in, and so that you will be revoked. Newsom versus State, 2004. A grand jury indictment is enough to revoke. Okay, so you get arrested. Okay, just because you're arrested doesn't mean you're guilty, right? Okay, so that's what the Benton case was about. I'm not going to revoke you just because you're arrested, because some people get arrested by mistake. Okay, but if you get indicted by a grand jury, that is enough to revoke. You don't have to be found guilty again. Okay, Reyes versus Tate. Revocation is still possible if the charges are dismissed. Okay, if you have an indictment, you're revoked, and then the indictment is dismissed, your revocation will still stand and it will still hold. The testimony of the community supervision officer is crucial in any testimony of the probation officer is crucial in any revocation hearing, because it's the probation officer that's been doing the supervising. He's the probation officer that knows the offender, and it's the probation officer that knows what's going on with the case. And if he doesn't testify, the revocation's not going to happen. Offender admission to the CSO, or the offender's admission to a crime to the community supervision officer, is sufficient to support revocation. And this is Fields versus State. You do not have the right to remain silent when you're on probation, and everything you say can and will be held against you in a court of law. Okay. And if you go into the probation officer's office, and they go, so what'd you do this week? He goes, well, I raped Judith. Well, he's going to file a motion to revoke on you because you said that you'd raped Judith, even if you were just joking. because that's an admission of guilt, it's an admission of a crime. He's going to file a motion to revoke, and that's all that's necessary. So if you ever find yourself on probation, don't be a clown and don't joke around. Reliable hearsay evidence during revocation hearings can be admitted in the hearing. And I always like that. I'm sitting on the stand and I'm talking, and I say, well, the defendant's wife told me that he was using and he was keeping the drugs behind the toilet. The defense attorney would always stand up and say, that's hearsay evidence and you can't operate on hearsay evidence and you are in violation and you violated his rights and this needs to be overturned. And I always like this, because the judge normally sits there and looks at me, and I like to sit there and say, well, counselor, in accordance with Belk versus Perkett, 1994, hearsay evidence in a revocation hearing is admissible, okay, and can be admitted in a revocation hearing, which we are doing here today. However, there is a test to determine whether or not the hearsay is reliable, and a yes to any of these questions does allow the hearsay evidence into a revocation hearing. Is the information corroborated by a parolee's own statement? Does the information fit within one of the expectations to the hearsay rule? And does the information have other substantial indications of reliability? If you say yes to any of those, the hearsay evidence is allowed. So, Bearden versus Georgia, and this is what I was talking about, fees. Okay, it can be added to, it can be something that's added to a revocation, but in accordance with Bearden versus Georgia, an indigent individual cannot have their probation revoked just because of the failure to pay their fees. Okay, they're not going to tell you this, and as a probation officer, you're not going to tell your defendant that. What's going to happen is they can extend their probation. They can extend misdemeanor probation up to 10 years for failure to pay. That's a long time to be on probation just to pay a bill. I recommend that you go get a job. Try and pay off those bills as quickly as possible. The State versus Grover stated that the offender must show the inability to pay was not willful. You have to show that you don't have a job. You have to show, this is how much I get paid. This is how much my rent is. This is how much I have, my bills. This is, how much I need to feed my children. This is my child support payment, blah, blah, blah. I don't have the payment to pay this. And they can't hold it against you. Juveniles cannot be sentenced to a term on probation any longer than an adult that committed the same crime. Time served does not usually get credited if revoked. Okay, so if and I've mentioned this before. I've had defendants who've been on probation for 10 years. Okay, and 9 years, 11 months, 3 weeks, and 6 days into their probation, they get busted for DWI. And I file a motion to revoke. And I get the motion to revoke to the DA's office before. I get the motion to revoke to the DA's office before the time expires. The DA signs it. I get the warrant. Now you've been on probation for 10 years for substance abuse with intent to deliver, for possession with intent to deliver. You've been on probation. You've completed 9 years, 11 months, 3 weeks, and you're almost done. I file the motion to revoke. You get arrested on the motion to revoke. You go to the court, and the judge says, I sentence you to 10 years in prison. You've already done 10 years on probation. Now you're going to go do 10 more years in prison. You don't get time served, typically, for the time that you've served on probation. Recidivism is defined by or as the rearrest or conviction. or you're returned to prison for another crime. The duration of that is subject studied from 2 to 3 years. Recidivism rate is from the time of your first arrest, and it goes through your sentence to 2 to 3 years after your sentence has completed, and if you get arrested again, that is the recidivism rate. 79,000 offenders were tracked over a 3-year period in 17 different states. 43% were rearrested within 3 years. 46% of that 43% was sent back to prison. 10 years later, 300,000 offenders, 67.5% were rearrested within 3 years of being released from the last charge. Okay, so this is modification and revocation of probation and parole. My name is Dr. John Fisher. I am glad to be talking to you today from the Moss Lake RV Park in Big Spring, Texas. And I hope you have a good week. And remember every day, you, as a probation officer or a parole officer, have the opportunity to change the world. John Fisher, this has been a good day. This has been a good lecture. Have a good day. Bye.